Ladies and gentlemen, I welcome all to my channel. Today, let us see what are all the essential ingredients to a valid contract. Indian Contract Act Section 10 says stipulates 5 elements for a valid contract. I read the relevant section. Section 10 says what agreements are contracts. All agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void. So the Indian contract the first element mentioned in the Indian contract is that there must be free consent. The consent of the parties has to be obtained without any coercion, undue influence, and the consent must be obtained freely without any pressure or malpractices. Supposing if a person the consent is obtained by threatening him, then that consent is not a free consent. Then on that contract, that agreement can be declared as a invalid agreement because the consent of the party were not obtained freely and it is not a free consent. And sometimes suppose there's a by mistake or by cheating, the consent is obtained, assent is obtained, then in that case is also we can say that aggrieved party may challenge the contract and nullify the contract as on the ground that the consent is not free. So the second one is called competency of the parties. One of the elements, important element for the essential valid contract is the parties must be competent to contract. A minor cannot make a contract. A person who is in insanity cannot make a contract. Similarly, supposing a person is not a proper owner, has no title over the property, he cannot make a contract. Supposing the property belongs to A and the agreement is made with his B, who is a son, who does not have the ownership over the property, in that case also the B is not a competent person. So the second important element required for a valid contract is the party must be competent to make the contract. The third one is there must be lawful consideration and lawful object. Supposing the consideration is not lawful and the object is not lawful, on that ground is also the agreement can be cancelled or nullified as declared as an invalid contract on the ground that such lawful the agreement is there is no lawful consideration, the object is not lawful. Supposing a person approaches the government department and offered to give some amount, supposing if a person approaches the government department to get a building plan and gave some amount and agreed to pay the balance amount once he obtains the required building plan, and the building plan is not given by the government authority, he cannot go and file a case saying that we have made a contract and we have paid a part amount and the particular person is not issuing the building plan as agreed and as per in the agreement. Here the object is not lawful. He was doing what the amount he is paying is a bribe. It is prohibited thing under the law. Bribery is prohibited, and one more thing, we cannot compel a person to do anything as against the law. So the object is lawful, consideration is lawful. So on the ground there is a possibility to struck down the agreement on the ground that the consideration is not lawful or the object is not lawful. Now another thing is called the agreement should not be a void agreement. So the void contracts are mentioned under section 24 to section 30 of the Act, that we will discuss in detail in the under separate head or void contract. So one of the void contract is that supposing if a person is wanted to do makes the person to do a illegal thing, or supposing there is an agreement with a party saying that you should not file any case, the agreement to restraining the person from filing a case or suit is said to be a void agreement. So, like that, various void agreements are mentioned under section 24 to 30 of the Act. That we can see. You can also go through this relevant section, and or otherwise, I will make a separate video on this subject. So if the agreement is void under this section, then it cannot be a valid contract. The last one is that supposing the law specifically says that this agreement should be in writing, then in that case the agreement should be in writing. Otherwise, it will not be valid. For example, if you purchase a property or if you mortgage a property, the law says that the particular law says that it should be mentioned in it should be in writing, and it should be registered with the concerned register office. So, suppose in such circumstances, if any sale deed is made or mortgage deed is made without proper registration, then the such agreement is not a valid contract. So, these are all the things mentioned under section 5, section 10 of the Indian Contract Act, which says that which stipulates 5 essential elements for a valid contract. We have 2 channels, Razak Satamarivom and Razak LawTube. One is in English, one is in Tamil. The students may watch my videos and enrich your knowledge, and you may also share this video with your friends. And I also request you to give your comments. That will help me to improve my videos. Thank you. Goodbye. Razak Ali.